A federal high court in Abuja has restored Senator Ararume as a non-executive chairman of the Nigerian National Petroleum Company Limited (NNPCL). Arise correspondent Godfrey Eshemoge reports.
The Federal High Court voided the sack of the businessman and set aside his removal last year by President Muhammadu Buhari on grounds that the action of the president was arbitrary, unlawful and illegal. In the judgment, Justice Inyang Eko awarded 5 billion naira against Buhari and the NNPC Limited to be paid to Ararume as damages for its wrongful sack and disruption of his appointment. Justice Eko therefore ordered that Ararume be immediately restored to office as the non-executive chairman of the company. The judge also declared as null and void all decisions of the board of directors of the NNPC Limited carried out in the plaintiff's absence.
The court was very thorough, very meticulous in its analysis of the facts of this case, and has shown that the laws are not made in vain. You cannot, as a regulatory body or as a statutory body, you come out with regulations, tomorrow you refuse to comply with them and you say they're permissive, they are not binding. Things must be done in accordance with due process and in accordance with the law. We are happy that the court has given judgment nullifying the removal, unlawful removal of Senator Ararume as the non-executive chairman of NNPC Limited.
Ararume had dragged Buhari before the court, praying it to declare his removal as illegal, unlawful and unconstitutional, and that it is a total breach of the Kama law under which the NNPC Limited was incorporated. Other defendants in the suit are the NNPC Limited and the Corporate Affairs Commission, CAC. Lawyers to the defendants were unavailable for comment after the court's judgment. Godfrey Eshemoge, Arise News.
Okay, Arise analyst Frank Tietie joins us now to make sense of the developing story on Ararume and the NNPCL. Good to see you, Frank, and thanks for your time as always. You know, sometimes you look at these issues and you keep asking yourself, first, there is an award, but again, take us through how we got here for Ararume and NNPCL.
Oh, well, there's been a long and tortuous journey to ensure that there is a Petroleum Industry Act. And after it was enacted, it was celebrated across the entire world, and it was a new dawn for the petroleum industry, and it has it bettered a new company called NNPC Limited, no longer a government-owned company, but a company according to Section 53 of the Petroleum Industry Act, a company that is meant to be commercially run according to the Company and Allied Matters Act as a commercial entity meant to make profit for its shareholders and then retaining 20% of whatever profit it gets for it to grow. And there was a requirement that within 6 months of its incorporation, it should actually be made, a board be set up. And in this case, the drama is that the setup of the board, according to Section 63 of the Petroleum Industry Act, requires that certain persons be appointed by the president as members of the board. In this case, the non-executive chairman along with non-executive members. Now, Ararume was on his own. Facts are that, facts of the case. He didn't lobby, he was just minding his own business, but a loyal, faithful party man, and president respects him and appointed him. But you see, the idea is that he went beyond that to also put his name, inscribe his name in the company document with the company registry, that is CAC. And for certain reasons, the president exercised his own powers of appointing to fire, forgetting that it's no longer a government-owned company, and then removed Ararume's name. Whereas Ararume, upon his pronouncement, had already started acting, he started visiting, representing NNPCL meetings in the US and all that. And, but there was something called inauguration, which came on that, at the point of inauguration, and Ararume's name was not there. And then Ararume felt offended because it had serious implications with regards to his reputation as a politician. So you appointed him and removed him without reason, without a recourse to him and all that. So he went to court. And this is the outcome of the Ararume's complaint to the court.
Yes,
that he
indeed.
be reinstated.
Is this where we should be talking about adherence to court order? Is that likely to happen considering all of the prayers that Justice Inyangekwo granted Ararume, of course, the 5 billion naira as damages. Ararume actually asked for 100 billion naira.
Yeah, because that's the extent to which he felt offended. But there's a lot more implications to this.
Right.
We're talking about a judgment order which not only reinstates Ararume immediately as the non-executive chairman of the NNPC Limited, but also makes far-reaching orders as to acts that were made while Ararume was absent, was illegally removed with regards to the decisions, resolutions, and whatever action the board of NNPCL had taken, nullifying him. That's a very grave implication, holds a very grave implication for the work of the NNPC, meaning that the NNPC is an international company. You must appreciate that, because much of its dealings are international, whether it is exporting or importing petroleum products, whether it's trying to ensure energy security of Nigeria. These are basically international transactions. Now, international confidence will therefore be very much affected when they now say, what's going on in Nigeria as a major oil company? You know, so that becomes a problem, because what the court is saying, that in the absence of any contrary order, if this order hasn't been set aside as we speak, as a matter of fact, Ararume is the non-executive chairman of the NNPCL. But again, why would the court make that kind of order? But that is what Ararume asked for, and unfortunately, the defendant's lawyers couldn't profile an argument to actually defeat that.
So does it mean that's it for this matter, or I mean, are there any options on the table for the NNPCL to explore?
Oh, you see, the implications are much more than that. For example, we're talking about investors' confidence and with regards to how much the NNPC operates on the international scale. Now, you have to weigh it on the balance. Does the NNPC, well, in this case, we're talking about, the NNPC is not in the eye of the storm, but the president himself, because what the court has actually done was to vilify, was to excoriate what the president has done by appointing a man and without for any lawful reason.
You know what I see here, Frank? Sorry to cut you. I want to take us back, and it has to do with NNPC and the Petroleum Act. Now, for many, they may not understand that the whole implication, because you actually started off by letting us know that there is an act in place, and also you also spoke about the Allied and Company
and Allied
Matters Act, which is very important here. And the doubts of some Nigerians are saying that perhaps it looks as if NNPC with the CL is just in the name, but but it's still acting as if and perhaps that was what made the president make this kind of errors by pushing Ararume out, thinking that NNPC was the old NNPC. Speak to us. You spoke about investors' confidence, and NNPC is supposed to be competing with Saudi, Aramco, Petrobras of Brazil, and the others. Now, what does this now tell us? Now that the wrongs are being corrected.
Now, a whole lot. For example, usually whenever there is a court of first instance judgment like this, the contemplation is that parties will want to rush to go on an appeal. But we're talking about a president who has barely a few days to leave office. So what will be in the interest of the NNPC? Is it going on appeal, or considering how to stave off a crisis with an Ararume coming back, being reinstated with the full weight of the law? These are considerations to be made. The NNPC is operating at its optimum as we speak. It's a leadership and management that has been turning things around, making profits on the level on tripling its profits in just the space of 1 year, and breaking bounds in terms of transparency. I'm talking about the administration of Mele Kyari. NNPC is doing well, just too well now.
And all this point to the act, to the good of the act.
Of course, particularly Section 53 of
all right,
the act.
Let's quickly put you on hold. Yes. We need to put you on hold so that you can comment on this next story. Two senior advocates of Nigeria have asked the Attorney General of the Federation, Abubakar Malami, to obey a court order. There you go, another issue of court order obedience in respect of a dispute on the multi-million naira e-customs modernization project. Well, the senior lawyers, Messrs. Ahmed Raji and Dikpo Okpesheyi, have in separate letters obtained by Rise News warned the AGF, the Minister of Finance, Budget and National Planning and Secretary to the Government of the Federation of underhand efforts being made to obtain the Federal Executive Council's approval and or ratification of the re-award of the e-Customs modernization project. But the lawyers are asking the Federal Executive Council to suspend, discontinue or discountenance any request to initiate deliberations or a fresh request for approval for the award of the said contract to any other bidder aside the original approval granted by FEC to Measures E-Customs Project Limited.
It centers around court orders.
What is this all about?
It's just about court orders. You know, our democracy, the foundation of our democracy is rules, and the rules are actually interpreted by the court. So if we want to have an enduring society, a government must be in the forefront of obeying court orders. That is, it must also, first of all, operate in such a manner, in such an environment where people will have less conflict. In this case, a Federal Executive Council has already approved a contract for a consortium, and then the they are bound to be conflicts, and then the matter is in court, and then the court gives an order, maintains status quo. At that point, the Federal Executive Council can no longer come and sit and re-award that contract to another entity. In the case of Ararume, which we were discussing before now, there hasn't been any body language on the part of the government to disobey the order, of which the judgment order. The court, what the government may have option is to probably approach the same Federal High Court for a stay of execution of the judgment or go on appeal. But in doing that, who do you help? Because we're just talking about the implication, the international dimension of this judgment on the impact of in investments on NNPC. So do you want the international community to say it's going to deal with someone who has a court order against him or court order in his favor? So is it not better that there's a quick resolution among the management, and again with an outgoing administration that would not have to give any baggage
is it late to apply your alternative dispute resolution to this?
No, the proper thing to do, and this is, and I speak as a lawyer, is that whenever a court delivers a judgment, immediately it is expected that all the parties, in this case the federal government represented by the president and the attorney general, together with the NNPCL and the Corporate Affairs Commission, are expected to comply. But you know, there's politics and there are implications, especially economic implications. In this case, which will be in the greater interest of Nigerians? Do we go on a wide good chase to go to the Supreme Court, or do we have a quick resolution by ensuring that the court orders are obeyed and NNPCL continues its wide stream of success under Mele Kyari? So nothing should actually derail or disrupt what the transformation that Mele Kyari is actually carrying on in NNPCL as we speak today.
And as you speak, as a lawyer now, if you were to put this pro bono, what should be what should be the way out so that NNPC, Nigerian, and the investors all don't suffer?
I will work as a Nigerian first and foremost. I will work and do everything possible to boost investors' confidence in the NNPCL. And in that case, let us make every effort to, play down on any conflict. Let's resolve every conflict.
What would that mean then? Will it mean that Ararume should now serve out his 5-year term? I mean, he was sworn in September.
Do not forget that when the president was in appointing Ararume, and the interesting thing is that Ararume's name is in the records in the company registry, and you need to know, as a corporate lawyer, you need to know how difficult it is to remove the names of first directors of a company, especially when they had no fault at all under the provision of Section 63, subsection 3, as the court has alluded to. In this case, as we speak, according to law, as a matter of fact, Ararume is the non-executive chairman of the NNPC. So what becomes necessary is the parties involved to come to the table to say, how do we resolve this without creating any form of distrust in investors' confidence?
And you didn't finish on that. You only said first as a Nigerian, you gave us the Nigerian aspect. So I wanted to see how investors and the NNPC can also profit.
Okay, so it's simple when you look at it this way. Now, do you want to continue in a state of doubt? So the clarity we have now has been made by the court. That is, this is the person who should be your non-executive chairman. But if you go on on a wide goose chase on contention, on appeal or stay of execution and proceed for another 1 or 2, 3 years, companies and international investors will be worried, thinking that the Supreme Court, if you ever go on appeal, may also undo whatever this board has done.
Yeah.
So is it not better that the person that a Nigerian politician like Ararume, who is expected to have the interest of the NNPCL or a friend of the president, should come to terms by applying the principle of ratification? Because the real problem here is when the court proceeds to say reinstate this man, pay him compensation, but it says that whatever was done in his absence becomes null and void. That becomes dangerous.
That's
But again,
right.
It's expected of a Nigerian, a well-intentioned Nigerian, to say, okay, for the sake of peace, if there's reinstatement, again, I ratify whatever has been done in my behalf or when I was absent.
Fantastic. Frank Tietie, as always, thank you very much. Lawyer and Arise News analyst. Thank you for joining us.